Good morning, everyone. Welcome. Our first case for argument this morning is the State of J. Anderson versus Mensa. Mr. Cade.
Good morning, Your Honors, and may it please the Court. Nathaniel Cade appearing on behalf of the appellant, the State of J. Anderson. The District Court committed several errors. Two of them I will deal with today. I will not address Monell, and I'll explain why in a moment. The two errors are, first, the District Court granted summary judgment to the estate when there was a disputed issue of material fact, specifically what was J. Anderson reaching for, if anything. The other error the District Court committed was it allowed the defense in the underlying case to file a late answer rather than holding the fact they failed to file an answer after the denial or partial denial of a motion to dismiss constituted admissions, at least for purposes of summary judgment. I will not address Monell today because obviously if the court rules against and denies the first cause, Monell is futile. With regards to the first error, the District Court erred because it made the assumption that J. Anderson was reaching for a weapon. As demonstrated in the photographs after the shooting, there was a phone that was on the front console. We don't know, based on the video, whether J. Anderson was actually reaching for a weapon, whether he was reaching for a phone.
That really doesn't matter in a case like this. What's important is what a reasonable officer would have interpreted that motion to be. And if a reasonable officer, based on an objective standard, would have interpreted it to be reaching for the gun on the front passenger seat, then that's the gist of the case. It doesn't matter if there was an alternative explanation. The jury is not going to have to decide that question. If this case were to go back to a jury.
Why would the jury not determine, Your Honor, because we're going to have both sides have experts, and both experts are going to say opposite things. Our expert is going to say that, I can't tell what he's reaching for, and he could have easily.
It's not a question for an expert. It's a question of whether a reasonable officer could have interpreted that double reach that the video shows, could have interpreted that as a reach for the gun. And if a reasonable officer, based on the objective standard, would have so interpreted it, then judgment for the defense follows as a matter of law.
As a matter of law, correct. However, there were
That's what the district judge said, and that's what the legal standard that applies to an excessive force claim.
Except the district court said, I find there was probable cause that he reached.
It doesn't matter what the district court said, first of all. What we can concentrate on here, because it's a de novo standard of review.
Certainly.
Summary judgment as the case comes to us. And what the video shows is a double motion toward the front passenger seat on which there was a gun. And if that motion was reasonably interpreted based on the objective standard as a motion for a gun, regardless of whether there was something else on the seat that the officer may or may not have seen.
Correct.
The important point is that, or the important question, and the only one on which liability turns, is if a reasonable officer in Officer Mensa's position, seeing that motion, would have interpreted it as a motion for a gun, reach for the gun, so that lethal force was justified.
Certainly, Your Honor. But a reasonable officer could have interpreted several things. A reasonable officer could, for example, J. Anderson was, we know, highly intoxicated. We don't know how long he had his hands up, where he's at a 90-degree angle with Joseph Mensa. So with Mensa saying stuff, when he turns, you and I, sober, can turn our heads while having our hands up. Someone who's intoxicated, he's turning. Is he purposely reaching, or is he turning? We don't know. And the problem is we don't know because a reasonable officer would have started the dash cam sooner. We would have had audio. We would know what was going on. Joseph Mensa has no recall whether he asked him for identification. He said, I did, and he said he didn't have it, but we know he did. So his veracity is at issue. We also know that Joseph Mensa said, when asked, did you tell him to put his hands up or on the dash? What'd you do? I don't recall. So a reasonable officer would have done several different things. So under the totality of the circumstances, we have to look at the entire existence, not just this move. If we just looked at this move, then what you are doing, Judge, is suggesting that the present case that's before the Supreme Court, Felix versus Barnes, where it's that moment in time under the Fifth Circuit, that's appropriate. That's not the standard.
No, I'm not arguing for a different standard or for the adoption of the Fifth Circuit's moment in time standard. That's not the standard in our circuit. So that's not what I'm suggesting, and that's not what the defense is arguing in this case. It's that as a matter of law, the motion could reasonably have been, or a reasonable officer could have interpreted that motion based on what the video shows of what happened as a reach for the gun. And there's no dispute that it was a gun.
Right, we're not disputing there was a gun. We don't know the orientation of the gun. We don't know which direction was pointed. We know none of that because the officers retrieved it for whatever reason, rather than leaving it for evidence collection. We don't know that, but what we know is there are other things on the seat. A reasonable officer would have seen, or likely have seen, the phone. All Joseph Mintz said is, I saw a gun and I reacted.
Even assuming that fact in your favor, that the officer saw the gun, or a reasonable officer, or saw the phone as well, or that a reasonable officer would have seen the phone in addition to the gun, that doesn't change anything as a legal matter here.
Let me ask you this. Chief Judge Sykes talked about a double reach. What is your position on the footage we've seen? Do you see a double reach? Do you dispute that he lowered his arm once? What's your view of what we're looking at?
We see him turning. There is no doubt. I don't know, again, because we lack audio, which would have been wonderful. Is he turning because he is being harassed by Joseph Mintz? He was drunk, had an argument with his girlfriend. He's in the park. He's woken up. So is he like, screw you, man, I'm going to call my dad?
Counsel, I think what's more helpful, if you go back, what I'm listening for, what we're needing you to answer, I believe, as my colleague is trying to pose, is what are the facts that are at issue? Would it need this to go back to the district court?
The facts that are at issue is, what was he reaching for? The only thing that we have is Joseph Mintz saying he was reaching for the gun. So you
accept, just so I make sure I understand, are you accepting the fact that there was a reach?
I'm accepting that he turned and that his hand dipped. The FBI looked at the video. They even tried doing infrared. They couldn't see that right hand at some point.
And so this idea, back to my question, of a double reach, that is not your position. That's not what you see in the video.
I'm not
a double reach.
I'm not disputing that he turns and that he's making that motion. I'm saying I don't know if it's because he's drunk. I don't know if it's because he wants his phone.
Okay.
If he's been insulted. The point is, the district court credited the only live witness by saying he was reaching for the gun.
Well, the reason I'm following up on this is because the district court, I don't recall the district court making a finding about a double reach, but the defendants certainly argue that he lowered his arm repeatedly. I don't know if you're saying you can't tell whether he repeatedly lowered his arm in the video. The defendants also say he lunged, and I don't know if you're saying you certainly can't tell if he lunged by looking at the video.
You can't
Those
tell
then, to circle back to Judge Pryor's question, would be factual issues better suited to a jury, which then reflects what a reasonable officer saw and would understand and could interpret.
Correct. I'm not saying that he lunged. I am saying that you can see that hand lower. Why did that hand lower? Is it because it was a reach, or because he's drunk keeping his hands up for a period of time? We don't know how long he had his hands up, right? We don't know if his hands are up for a minute or for 4 minutes. We know Joseph Mintz is in the park. Between the time he radios in when he goes to the park and he sees the vehicle, it's just under 6 minutes. We know that he radios about the license plate. We know that the car is not reported stolen, and they give a name. It's a female name, so obviously this individual is not the female. What else occurs? Joseph Mintz says, I asked for ID. He said he didn't have it. We know at the autopsy, when they cut open his pants, he had identification. We know Joseph Mensah never radios in, hey, this is the name of the suspect, Jay Anderson, date of birth, to see if he's a wanted felon. All he did is, I saw a gun, and he reports it. That's it. Everything else, is he turning because he's reaching for the gun? Is he turning because he's drunk? Is he turning because Joseph Mensah said something and he wants to call the phone?
So is it the factual question for you is whether or not he was lowering his hand?
He could have been because he was lowering his hand. He could have been because
No,
he...
I'm asking. I'm asking.
Oh, I'm sorry.
The question.
We don't know. I mean, literally all we can see on the video is, and I can't assume that it was a definitive lower. I can't assume it's because he's intoxicated, right? If I'm sober, I can turn and look at Joseph Mensah. If I'm drunk, you know...
You keep emphasizing this, Mr. Cade, and it really doesn't matter if there's an alternative explanation, because we don't use 20/20 hindsight in evaluating the split-second decisions of police officers in the field in responding to armed suspects. And this was an armed suspect. The gun is on the seat, and the officer knows it, sees it,
Correct.
and the suspect lowers his arm twice. That's what the video shows. You're not disputing that. As far as I hear your answers, you're disputing the reasons for it.
I'm saying his hand lowers. I'm not saying it's a reach, Judge. But
I know you're
Are you saying
you're
the hand-
recharacterizing it, but the video shows that the hand goes down twice, and I don't hear you disputing that. Are you?
I'm saying his hand dips. Whether you call that going down under the dash, we can't see.
Twice.
Correct. But
Okay,
Judge,
you're not disputing that.
You have said in a state of Beager, it was the decision you were a panel on,
The court
having a
has-
weapon is not the same thing as threatening to use a weapon. He never touched the weapon. He didn't, the fact that he's...
But we have lots and lots of cases that say the officer does not need to wait in that situation for the gun to be engaged and fired.
But there's a difference between engaged in fire and touching a weapon. He doesn't even have physical possession of it to do anything with. There is a difference. In fact, we even have the Weinman versus McClone, where the individual is holding a gun, holding a shotgun. An officer decides to bust in. It's never raised. He physically has it and just shoots the subject. Under this interpretation, the fact that, well, he had a gun and I'm concerned I can shoot him, Weinman would go the other way, and that's not the case. Here, all we know is Joseph Mensah has tunnel vision, and he says he's reaching for the gun, right? But that's really a jury question as to what a reasonable officer would do. Is he reaching for the gun, or is he reaching for the phone? Reaching for the bottle of water in the dash console? I don't know, and no one else knows, but that's
I
a
think we're
jury
somewhat
question.
conflating the two. The jury is going to be answering fact questions,
Correct.
right? And so that's why Judge Jackson-Huey is really trying to drill down on the facts that you are disputing. And Chief Sykes is wanting to know as far as what are you asking the jury to decide from a legal standpoint?
I think a jury has to decide with regards to what a reasonable officer, once they hear the testimony, is it reasonable for Joseph Mensah, an objective officer, to have that belief that he was reaching for the gun? And I'm well within my rebuttal time, unless there are other questions.
Thank you.
Thank you.
Ms. Baynard.
Good morning, Your Honors. May it please the Court. My name is Jasmine Baynard, and I represent the appellee, Joseph Mensah. This is a case in which Officer Mensah was confronted by Mr. Anderson's immediate access to and is reaching for a loaded firearm despite repeated instructions not to do so.
Do we know that there are repeated instructions? Because as I read Mensah's sworn statements, doesn't seem like he remembers giving repeated instructions. He does remember one thing in particular, saying, I see the gun, don't reach for the gun. But I don't see him saying he remembers giving repeated instructions or any other he's got a lot of I don't knows in terms of what he said to Mr. Anderson, which is a little difficult from a record point of view.
Your Honor, I would submit that Joseph Mensah, and when we're talking about statements that Joseph Mensah has given, it's this incident happened in 2016. He gives a statement immediately afterwards. 8 years later, during his deposition, I will agree with the court that there are instances where he says he does not recall and refers back. If we refer back to his original statements, it's, I don't know if I'm telling him don't touch the gun, don't reach for it, but I am telling him do not do that, do not do that. So if more than one time he's instructing and it's his perception that Anderson can hear him and can understand him, and deliberately chooses not to follow that command. Now, the court reviewed the record, and I know that in the briefings and in the papers there is a lot made to do by my friends on the other side about this idea that the court had nothing to review in coming to its summary judgment decision other than Mensah's testimony. But that's not true. We have Mensah's testimony, we have the dispatch audio, we have the video that demonstrates, although a small portion of what happened, a portion of what happened. And during that, and we have that video because Joseph Mensah wanted there to be that video. It's because he hit his mic, it's because it recorded 30 seconds back, and that's why we have that video. Now, when the district court evaluated that record, the district court made it clear in its order and its order on the reconsideration that it wasn't just crediting Officer Mensah. It was looking at the video and determining under the applicable standard what a reasonable officer under the circumstances would have found. The district court said, I don't know if Anderson was reaching for a gun or a phone. We will never know, and that's not a question the jury can answer. The district court or appellants challenged the district court's alleged decision that that the gun was loaded. The district court didn't make that finding. The district court said, I have no way of knowing if the gun was loaded.
Let me ask you this. If we knew more than we did now, if we had more audio, and we knew whether Mr. Anderson put his hands up on his own accord versus Mensah telling him, because we don't know that Mensah told him that. Mensah has said, I don't know whether I told him to put his hands up or not. Okay? So if we had audio and Anderson says, you know what, officer, I'm just going to go ahead and put my hands up. And if we had audio where Mr. Anderson says, my hands are up, officer, but I'd like to get my cell phone to record this encounter, so I'm going to reach for my cell phone, officer. If we had audio depicting that scenario, giving us that scenario, could a jury, is it conceivable that a jury would listen to that, look at this footage, listen to Mensah's testimony, and decide that it was not reasonable for an officer under those circumstances to think that Mr. Anderson is reaching for a gun, and therefore there's an imminent threat of harm such that deadly force is necessary?
Your Honor, I mean, respectfully, this is I think an invitation to do a lot of 20/20 hindsight, Monday morning quarterbacking. I think that if there was audio, or say this went to a jury and the jury got Mr. Anderson's BAC or found out that he had marijuana in his...
No, I'm asking my question. My question to you is, if we had audio, we don't have audio because Officer Mensah didn't turn on his recording earlier. But if we had audio, under those circumstances, with those facts, could a jury determine that a reasonable officer would not have thought he could shoot the man?
I think a jury could, under those facts only, that Anderson said, I want to reach for my phone to... I think a jury still could find that a reasonable officer saying, if you have a phone next to a gun, and I'm saying, do not reach for the gun, I'm not sure that I don't know what a jury would do, but I don't think that we can. I don't think we can assume that under those facts, even if the jury had that, that the officer doesn't get to give him the benefit of the doubt. The officer doesn't have to wait or say, hey, okay, fine, slowly just reach for, or let me walk up to you, pull the gun away, and then you can take your phone out and start recording.
Which is why it's not a jury question at all under our case law.
I agree with you.
It's a question of law because we have lots of cases that say that officers don't have to take suspects at their word, that they're doing something benign when there's a gun involved.
Yeah.
And so the officer wasn't required to consider, much less accept, a benign explanation from a suspect under these circumstances, and a verdict as a matter of law would follow from that evidence, or summary judgment, or at the very least qualified immunity.
And Your Honor, I agree, and respectfully to your point, if we're taking some of these what ifs or factors, I think then I can move to my next point is then even if some of the actions, or if Officer Mensah could have done something differently or didn't act perfectly reasonable, we still have qualified immunity, and qualified immunity in this circuit would stop the case even if the court didn't decide on the merits, because we are not looking at and saying, well, what if, or taking all of these potential scenarios into consideration, because Officer Mensah saw the gun, he identifies the gun, he radios the backup and says he's got a gun. So while I believe this case rises and falls on substantive law and the issues of qualified or under the Fourth Amendment and the video evidence that we have.
So you're questioning whether or not there was a constitutional violation in the first place, if we move to qualified immunity, as to whether or not there was a violation of excessive force or use of excessive force.
I guess I'm not questioning whether there was a constitutional violation at all. What I am trying to do was answer the judge's question that what if we had additional information? Could a jury decide something else? And I'm taking it back to, well, in that situation, I still believe this would be a case for qualified immunity. And I hope that answers your question.
I don't believe it does, because if we accept the hypothetical that was given, there are then disputed facts. And so if there are disputed facts, then qualified immunity would not apply. Of course, the officer could, after the facts have been presented and decided, again apply for qualified immunity. So I don't think that where you're going, counsel, would be appropriate based on the hypothetical that was given. So I question where you're headed.
I guess what I'm trying to say is I get that I'm being given hypotheticals, taking it back to what we know in this case and what Chief Judge kind of explained, that it would be as a matter of law. It's not a question. So if we knew that he wanted to reach for a phone next to a gun, it wouldn't matter. It would not matter. That's not a dispute of fact. And even if an officer should have taken, which he's not required to, a suspect's word, there's no dispute that the gun's on the seat. I think and I mean, I don't know if it's a dispute for the purpose of where we're at now, but whether the phone was on the seat or anything else, right? The photographs that have been...
The reason why I'm going there, because in Wisconsin, it's not a violation to have a gun out on the seat.
So in Wisconsin, is an open carry state, you can't open carry a gun on a passenger seat of a vehicle. And you also can't possess...
You can or cannot?
Cannot in the passenger seat of the vehicle.
In a parked car.
I'm not sure if the parked or the moving car matters. It's an open carry state, so you can't have it concealed on the passenger side at all. And with regards to this kind of possession, even if, and again, trying to
Not
avoid
concealed, you mean open, right?
Yes, open carry. And without trying to do, I don't want to play the second guessing of 20/20 hindsight. There's no, I guess the possession of the firearm would not have been legal under Wisconsin law anyway because of Mr. Anderson's intoxication.
Let me tell you, I don't, my question was not a pure hypothetical I'm pointing to the information we don't have because we don't have it in the record. We don't have the audio. And I have to be mindful as we are deciding the case of our case law that says in these excessive force cases, you don't, if the person's dead, you don't have their testimony. And all we have is the officer's testimony. So we have to be wary of deciding these on summary judgment. That has to be married with our law about officers' reasonable use of imminent force and split-second decisions and so forth, so on. All of that law is on the table. And here we don't have the facts. A jury wouldn't have the facts of what Mr. Anderson was saying that might have influenced a reasonable officer in that moment, an objective, objective decisions by a reasonable officer in that moment. So I just wanted to address, it wasn't a pure hypothetical. I'm asking, there are gaps in the record because Mr. Anderson is dead, because the video is of the quality it is, and because Mensa said he doesn't know exactly what he said to Mr. Anderson.
Your Honor, I agree with you, and I understand that the case law in the circuit with regards to deciding excessive force cases when we only have the testimony of the live witness, and in cases where video is available, and I believe the district court relied on this and said, yes, I'm looking at when I have video, although video can be open to different interpretations. In the King case, if I have video, we're looking at the evidence as a whole, I have video that does not contradict, and I believe that the court understands or has viewed the video, and you see this reach towards a gun. So when we're talking about the facts that are undisputed, whether there's gaps, there's never going to be a perfect record. They didn't have body cams then. Even if we would have had a video of the whole 6 minutes, I'm not sure if you would have heard anything Anderson was saying. This was 2016. Now police officers have body cam. Things are a little bit different, but I don't believe that affirming the district court's decision would be contrary to the court or the case law on the circuit that says if we don't have, we should be wary of granting, summary judgment in a case. If we had no video, we probably would not be here, right? If there was no video that kind of substantiated Officer Mensa's testimony, then maybe we'd be in a different posture. But the video does not. The video does support it. And the undisputed facts that the gun is there, he's reaching for it, Mensa perceived him to be reaching for it. No reasonable fact finder.
But you do understand Anderson's estate is contesting what you say is a reach for a gun, so that would not be undisputed. Anderson's estate is saying he turns, it's a lowering, but certainly not a lunge, not a reach, not a double reach.
And I guess I don't understand them to be actually disputing that, but even if we talk about disputes, there's a difference between disputing and having a genuine dispute of material fact. So, and honestly, Anderson's motivation is irrelevant to the analysis. So there's a gun there. The officer believes him to be reaching for the gun. Whether he made a quick reach for his phone, again, we will never know, and maybe if we did, that would make the situation even more tragic because that's not fallen on me, that it is a very, very unfortunate situation, however it plays out. But the case law in this circuit and in the Supreme Court in qualified immunity was made for cases like this. And for those reasons, I ask that the court affirm the lower court's decision. And with that, my time is concluded.
Thank you. Mr. Cade.
Thank you, Your Honor. Briefly in rebuttal, Judge Pryor, in response, it was not a concealed weapon in Wisconsin. 941.23 of the Wisconsin statutes, there are 3 elements. The third element is the weapon was concealed or hidden from ordinary observation. That's State versus Keith, 498 Northwest 2nd, 865, 1993. It wasn't hidden from observation because Joseph Mensa saw it, so it's no longer a concealed weapon. There's no doubt Joseph Mensa, had he been arrested at that point in time, would have been convicted for being armed while intoxicated if they had done blood alcohol content. It's a misdemeanor, as is carrying a concealed weapon. It's a misdemeanor, not a felony. The issue that I'd like to leave the court with is everything that my colleague here has said goes on the inference that there was a reach as opposed to dipping of the hand as opposed to anything else. And the question again is, would a reasonable officer believe that to be the case, that it was a reach or that he was dipping? Again, as you indicated, we don't have audio. I heard, Joseph Mensah wanted everyone to see the video. If Joseph Mensah wanted people to see the video, he would have turned on his squad lights the minute he got into the park. That would have activated the video and the audio. Joseph Mensah, when he first had contact, would have activated from his chest to turn on the dash cam. So it can't be that Joseph Mensah wanted posterity when that's not the case. Thank you. We ask the district court be reversed.
Thank you. We'll take the case under advisement. Our second case this morning is Griselda Ontiveros versus ExxonMobil. Ms. Abraham.
Good morning. May it please the court, my name is Christina Abraham and I represent the plaintiff appellant Griselda Ontiveros. The district court erred by granting summary judgment despite extensive circumstantial evidence of gender discrimination, age discrimination, and retaliation viewed improperly in isolation rather than holistically as required under Ortiz. Under Reeves, a jury, not the court, must resolve credibility disputes and assess whether the employer's stated reason was pretext for unlawful discrimination. At this stage, the district court was obligated to disregard evidence favorable to the defendant that the jury is not required to believe. Courts must review the evidence in the light most favorable to the non-movement and refrain from weighing credibility. The court improperly required each piece of evidence to independently prove discriminatory intent instead of applying the holistic approach mandated by Ortiz. The court ignored key circumstantial evidence and comparator evidence and improperly credited defendant's narrative without allowing the jury to assess pretext. The court ignored this court's advisement under Sylvester that a case of discrimination can be made by assembling a number of pieces of evidence, none meaningful in itself, consistent with the proposition of statistical theory that a number of observations, each of which supports a proposition only weakly, can, when taken as a whole, provide strong support if all point in the same direction. The court erred in its gender discrimination analysis because it dismissed inappropriate behavior like staring, winking, and inappropriate remarks as unrelated, but these comments contributed to a bigger picture showing gender bias. It failed to consider the evidence holistically. It failed to consider evidence that the performance assessment process was itself predetermined and that the PIP offered to Ms. Ontiveros was just a formality. It failed to consider the testimony of a supervisor who admitted that no male employees were subject to the management of lower ranking performance or MLRP process, despite them also having performance issues. It credited Sanchez's claim that he received verbal complaints about plaintiff that he never documented, there was no record of. It credited defendant's claim that plaintiff was terminated because of her behavior at a performance review meeting, which events she disputes and the court acknowledged were disputed.
Ms. Abraham, before
Yes.
you get any deeper into that evidence in the case, Exxon fired your client for her unprofessional behavior during the meeting on her performance improvement plan, and then her failure to respond to their follow-ups after she stormed out of that meeting, and otherwise behaved unprofessionally. And then when she didn't respond, the company terminated her. That's a non-discriminatory reason, and there's no evidence that the company didn't genuinely believe that reason and was using it as a pretext for any form of discrimination, age or sex-related discrimination. And I haven't seen a satisfactory answer to that aspect of the case, regardless of how this winking, et cetera, can be interpreted.
I do think that there is evidence that shows that their interpretation or their presentment of her behavior at that meeting
Doesn't
was
really matter if there's a
exaggerated.
dispute about that. The question is whether the company genuinely
Correct.
believed that she had behaved unprofessionally. In other words, you need some evidence of pretext that it was cover-up for, it was a lie, it was a cover-up for their real reason, which was discrimination. And
Correct.
there isn't any record evidence showing that that reason was pretextual.
I do think there is evidence that there is that reason was pretext, and I'll tell you why. First is the evidence that the whole thing was predetermined, that when they put her on the PIP, that it was for the purpose of terminating her. Because we have Sanchez and Villatoro on record saying that the PIP process was a formality to terminate an employee, and Sanchez saying that he couldn't really terminate people without putting them through that assessment process. And we have evidence in the record that shows the decision was made to terminate her back in January. But in addition to this, her version of events of what occurred at that meeting was disputed. Sanchez's and McGuire's relay of what happened could be interpreted by a jury to be exaggerated because in addition to the pretext, the fact that the PIP was predetermined, we have evidence that Exxon tolerated a culture at this plant especially, wherein people would yell, were emotional, would berate one another, there was cursing, and they tolerated all that. People didn't get fired for it. Moreover, they gave her 21 days to make a decision, and then Sanchez backtracked on that. That's inconsistency. So while a jury could believe possibly that their reasoning was honest, I think a reasonable inference could also be drawn that it wasn't, that it was exaggerated for the purpose of getting rid of her. That they saw this.
Do we have anything suggesting that she was placed on the MLRP program because of her sex?
Yes. So going to the culture at the plant at the time that Sanchez became the plant manager. So in 2019, females had made up only about 10% of the Cicero plant's employee, and yet they were 100% of employees that were subject to the MLRP process. That is statistically improbable if the process was neutral. Sanchez and Villatoro admitted that no male employees were placed in MLRP that year, even though they acknowledged that they had problems with male employees' performance. Like, there's a record, for example, that one of the employees, the male employees, his work was called garbage. No male employees were subject, and Sanchez didn't fire anybody through that MLRP process. Villatoro and others described the PIP process as a formality. We have a witness, a former employee, Margaret Jaziorsky, saying that she was told by another supervisor that when she was presented with the PIP, because she was part of that weeding out of women at the plant, that it was just a formality and that it was impossible for her to pass it. In other words, she wasn't going to keep her job if she decided to go on the PIP. And the reason for that was to pressure women to take the severance or pay in lieu options. So they would leave resigning instead of there being a record of them being fired. Does that answer your question?
No, it doesn't, because I'm trying to drill down on what ties her placement on the MLRP to her sex discrimination or age discrimination claim.
So with her placement on the MLRP, we have a number of bits of evidence that point to the gender discrimination. So in addition to the predetermined and the use of the abuse of the PIP process.
But see, the PIP process is once you're placed on the management of lower relative performance. What I'm trying to connect up is your argument that once you were placed on this, so what is triggering women getting placed on MLRP?
Yes, and thank you for asking that and for clarifying that. It's an important piece of the story. So the process starts with a preliminary assessment that local managers give to the employee. And that preliminary assessment, as we see from the record, is determinative or highly influential of the final outcome.
Okay.
Does that answer your question?
Yes. And so what was her grade, her preliminary grade?
For that year, it was a D.
And then her final grade?
A D.
All right. And so is the suggestion that she was given a D because of her sex?
Correct. Yes.
And what evidence do we have of that? You said the culture.
The culture. There's evidence, for example, about Sanchez making derogatory comments towards women, like he told plaintiff that she should sit on his lap during a meeting. He made fun of the weight of another female employee. He made fun of another female supervisor's voice. That's Karen Hasberger. She was later removed from plant stewardship meetings without explanation, and she was also subject to the MLRP process. Both these female employees that I'm referring to had to leave the company because of the environment. These were not stray remarks under Ortiz. They're part of a broader context that show bias. And admittedly, this is not smoking gun evidence that would make the intent easy to determine, but I think this court observed long ago that employers long ago taught their supervisory employees not to put discriminatory beliefs into attitudes or attitudes into words, oral or written, and that's from true.
So even if we accept that she's satisfied under McDouglas or Ortiz that she's established this prima facie case, if we move to the last element, now they've presented, if ExxonMobil comes and says, but this is the real reason that she was terminated, irrespective of the fact that she was now in the MLRP program, her behavior at this meeting when we were going over the PIP, going over this, that was pretextual.
I think that's a reasonable inference that could be drawn, but it's not the only reasonable inference that could be drawn. And because you have multiple reasonable inferences that could be drawn from the evidence that's in a whole, this should be resolved by a jury. Because I think a jury could also see that the process had been predetermined, that from January they'd made a decision that they were going to get rid of her, that Sanchez understood he needed to use that assessment process to do that.
But do we have any at this? We have those prior before they're put on the MLRP, but I'm wanting to kind of transition and move forward. In the history of this case, was there any comparators to people who had behaved in that manner at the PIP process?
There's no,
that's where I'm trying to get you to.
yeah. It's interesting because there's no men I can point to that were even put through that MLRP process and presented with this option. But what I can tell you is that if you look at Plaintiff Exhibit 13, you'll see the investigation report of Chris Halstead, and he does talk about men having performance issues. Their work was criticized at the plant. You just don't see a record of it because they were protected. Does that answer your question?
So there were no men on the MLRP?
No, not at this plant, not at the Cicero plant, not under Sanchez and Villatoro. And I think that's, like I said, it's statistically improbable when you're looking at the fact that 10% of the workforce was women and 90% were men, but 100% of the people who were faced with this MLRP were women, such that by the end of that process, the only female that was left at the plant was Nicole Salvaggio, who was hired outside the Exxon standard process by Raul Sanchez, who was regarded as a younger, attractive female employee who was never yelled at and given more favorable treatment for that reason. I see I'm nearing my time. If there are any other questions, I'd be happy to answer them, but if not, I'll reserve the rest of my time for rebuttal.
Thank you. That's fine. Ms. Nguyen.
Good morning. May it please the court, my name is Amy Nguyen and I represent the defendant appellee ExxonMobil Corporation. Plaintiff's employment with Exxon ultimately terminated back in 2019 because she engaged in insubordinate, unprofessional behavior when she was told that Exxon had placed her in the lowest possible category in the performance assessment process, here that was a D, and that she would be put into the MLRP process, in which she had to choose whether to go on a performance improvement plan or stop actively working and receive salary and other benefits prior to resigning on a specified date. We call that pay in lieu. When plaintiff was told of her D rating, she got up to leave before the meeting was over, threw the MLRP paperwork across the table, started yelling, and then refused to leave the facility when she was told. And due to that behavior, Exxon decided to remove plaintiff's option to go on the performance improvement plan. She could either take the pay in lieu or be terminated. After a holistic review of the evidence and giving plaintiff the benefit of all reasonable inferences, the district court properly decided that no reasonable juror could conclude that Exxon had assessed plaintiff's performance as a D or ultimately terminated her employment after removing the PIP option because of her gender or her age or in retaliation for her workplace complaints, and this court should affirm that decision. I'll start with plaintiff's gender claims first and then move on to her age and retaliation claims, noting that many of her failures of proof apply across all of her claims. So with respect to plaintiff's gender claim, the district court considered and addressed everything plaintiff put before it and correctly concluded that she did not establish a prima facie case under McDonnell Douglas and did not otherwise point to evidence from which a reasonable fact finder could conclude that gender was a factor in her 2019 performance assessment or her separation. With respect to her rating, she couldn't show she was meeting Exxon's legitimate performance expectations when she received the D, or that the assessment process was somehow tainted by discrimination. As the district court correctly noted, the factual record reflected plaintiff's performance had been deteriorating over time. She went from B's to a C to a D over a 4-year period from 2016 to 2019 with the same kinds of performance issues year over year, identified by 2 different supervisors and contemporaneously documented. She didn't identify any similarly situated men who were treated more favorably in the assessment process. To the contrary, plaintiff conceded that there was a man, Stephen Kimber, in her same assessment group in 2019 that also received a D and also was placed in the MLRP process. Instead, plaintiff generally focuses on male employees at the Cicero plant, even though they weren't part of her performance assessment group. It's not the proper assessment comparison group, and her gender claim fails for this additional reason. And despite plaintiff's conjectures in her brief, there is no evidence that plaintiff's D ranking or the PIP process was predetermined or tainted. That argument shouldn't even be considered by this court because plaintiff didn't make it below. But regardless, there's no evidentiary support for that claim given the uncontroverted facts of the record. With respect to the PIP option removal, she hasn't identified any evidence that her gender had anything to do with that decision to remove the PIP option after her insubordinate and disrespectful behavior, or that she could even establish a prima facie case. Behavior like the plaintiff's behavior on the day she was told of her rating failed to meet legitimate performance expectations, nor did she identify any similarly situated man who engaged in similar misconduct and was treated more favorably. And with respect to her pretext argument, there's no evidence that Exxon did not honestly believe that plaintiff had engaged in that insubordinate behavior, nor is there any evidence that casts doubt on Exxon's stated reasons for removing the PIP option.
So just want to make sure there are men on the MLRP.
There are men on the MLRP. Those men may be in different assessment groups, but yes, Stephen Kimber is an example of one who was placed in the MLRP from plaintiff's same assessment group.
From her assessment group.
Her assessment group.
Potentially might not have been working at the Cicero plant.
Exactly.
Got it.
Exactly.
Okay.
But while we're on the MLRP, let me ask a record question. So her 2019 performance review, there are 2 blank pages that we can see, and it's just a short statement that says MLRP issued and options clearly explained. Were those pages originally blank, and is there anywhere in the record explaining why Villatoro cited, what exactly Villatoro cited to downgrade Ms. Ontiveros' performance rating to a D?
Sure, thank you for the question. So yes, those 2019 performance assessment records are blank in their original form. They're not redacted or anything like that. And what is reflected, the documents that best reflect the series of issues that led to the D are the draft performance improvement plan document that's attached as part of the record in Mr. Villatoro's deposition. So you will see a draft performance improvement plan that was prepared that is reflective of all of the issues in a summarized way that reflect the D.
And is that standard? So you put nothing in the performance review and put everything in this draft PIP that the employee may or may not agree to sign on to?
That wasn't developed in the record, whether or not it was standard or not, but that's my understanding.
Okay.
Plaintiff's self-serving denials and the attempt to downplay the seriousness of her behavior at the performance assessment meeting does not create a genuine issue of material fact as to Exxon's legitimate business justifications for removing the PIP or with respect to pretext. The deposition testimony of the Exxon representatives who were present, Raul Sanchez, the plant manager, and Shannon McGuire from HR, recounted the behavior that day. There's contemporaneous documentation and email correspondence reflecting plaintiff's behavior that day, and plaintiff herself doesn't dispute that she got upset, she walked out of the meeting before it was over, and she was told to leave the building. All of this supports ExxonMobil's honest belief that plaintiff engaged in insubordinate behavior that day, and the law is well settled that courts don't sit as super personnel departments to reevaluate that conclusion. And plaintiff has no evidence that ExxonMobil quote-unquote exaggerated her behavior like she now claims before this court in her brief. Plaintiff could have deposed others present in the office that day, but she didn't. And if all it took to survive summary judgment was for a terminated employee simply to say she didn't engage in the bad behavior that the employer honestly believes she did, despite a record of supporting evidence of that bad behavior, virtually every termination case would survive summary judgment. She has no evidence of pretext, and the district court's decision should be affirmed. Her various arguments about the alleged treatment of other female employees at the Cicero plant as evidence of discrimination against her were also considered and properly rejected by the district court. She assumes without any evidence that Sanchez, as a plant manager, was involved in assessments of everyone who worked at the Cicero plant. The record evidence shows that that was not the case and not how the assessment process worked. And furthermore, she doesn't have any evidence that there was anything discriminatory about the separation of other women from Cicero, most of whom were in different positions and involved different decision makers. In short, plaintiff's own speculations, or her leaps of logic, as the district court called it, about other employee separations are not enough for a reasonable fact finder to conclude that plaintiff's performance assessment or her separation was discriminatory. My friend's arguments about stray remarks and inappropriate comments by Sanchez don't save her claims either. To be clear, there's no sexual harassment claim in this case, but plaintiff wants this court to leap to the conclusion that the comments she alleges Sanchez made are evidence of gender discrimination against her. The district court didn't ignore this or assess credibility when reflecting on this evidence. It correctly concluded that even if the comments were made, they weren't evidence of gender discrimination because they were unrelated to any of the decisions at issue in this case. And in the absence of any evidence linking the decisions that plaintiff is challenging in her lawsuit today to her gender, her claims fail. And her age claims fare no better. There's no evidence concerning the decisions that she's challenging were due to her age. Her 2019 assessment, she can't show that but for her age, she wouldn't have been assessed as a D. As I said before, the record evidence amply demonstrates her ongoing performance issues. Other younger employees she identified, Nicole Salvaggio, Salvatore Saucedo, they're not similarly situated comparators in all material.
Were either one of them in her assessment group?
No. Plaintiff has no evidence that Salvaggio or Saucedo had performance issues like she did or engaged in insubordinate or disrespectful behavior like plaintiff did. That's what she needed to show, and she didn't. Instead, she claims without any evidence in the record that Salvaggio received preferential treatment from Sanchez in the hiring process. Salvaggio wasn't deposed in this case. And she claims another older employee was offered a PIP in the MLRP process when Saucedo was not in the MLRP. But there's nothing in the record that suggests that Exxon's decision had anything to do with age. It's pure speculation on her part, not evidence. And nor has she pointed to any evidence that but for her age, Exxon would not have removed her PIP option due to the insubordinate behavior or identified any other similarly situated comparator or other evidence to support that age was a factor in that decision. Plaintiff did not address at all retaliation claim in oral argument here, but I'll just touch on it briefly. She has not come forward with any evidence to support the retaliation claims that she makes in her brief. The record shows that neither of her two internal complaints involved age discrimination or harassment. Her first complaint was in October of 2018 about payment for overtime work. The second one was in November of 2018 about what plaintiff thought was Sanchez and Viatoro's harsh management styles. But nothing in the record reflects that she complained about sex or age discrimination or sexual.
What about the November 2018 one where she's asked and she says she does not feel the treatment was motivated by gender alone, which indicates that she's saying gender was one of the things. It's just not the only thing. And then she talks about feeling targeted because she doesn't dress up for work. Why aren't those two things enough to say that she complained about gender discrimination?
I don't think those two things are enough given when you look at the totality of the things that she was complaining about and what she first reported at the end of the day. And in any event, even if that November 2018 complaint were legally protected activity, she still doesn't have any evidence from which a reasonable fact finder could conclude that had she not made that internal complaint, that she wouldn't have been assessed as a D and that she wouldn't have had the PIP option removed due to her insubordinate and unprofessional behavior. The evidence demonstrated that Villatoro was actively managing her performance well before the November 2018 complaint. He was raising issues with her about her performance, and when the same kind of performance feedback was being delivered both before and after the complaint, the retaliation theory just doesn't work. There's no evidence that the performance feedback, which was well documented, was unjustified or pretextual, and no evidence that Villatoro treated anyone else who he supervised with similar performance issues more favorably.
Were there any men on the MLRP under Villatoro or Sanchez's supervision?
Not during this relevant period, but in past, but not at this particular time. Lastly, plaintiff hasn't pointed to any evidence suggesting that she would not have been terminated in September of 2019, but for her complaint 10 months earlier. The district court properly arrived at these same conclusions, properly applying the legal standards, and this court should affirm. In conclusion, plaintiff was required to come forward with evidence of discrimination on the basis of her gender and her age, and evidence that she was retaliated against for making an internal complaint that was statutorily protected. And she failed to do that. Instead, she's only presented her unsupported speculations about the performance assessment process and her disagreement about whether her behavior was insubordinate, and that's not sufficient to defeat summary judgment. The district court got it right in this case, and that decision should be affirmed. If there are no further questions, we'll cede my time. Thank you.
Ms. Abraham.
So a few points for rebuttal. The evidence of performance review manipulation includes, first, that Stephen Kimber did not work at the Cicero plant.
I'm sorry, just a little bit louder.
Oh, I'm sorry. Stephen Kimber did not work at the Cicero plant. He was not given a preliminary assessment rank by Villatoro or Sanchez. So what happens at the preliminary assessment, the local supervisors give you that rank. Then they go and they present on you for 2 minutes at a final assessment meeting, and that's where you see those final ranks entered. So the fact that Stephen Kimber from a different plant under different supervisors got a D is irrelevant to how Ms. Ontiveros got her D. Villatoro admitted—
It would not be irrelevant if what you described is the assessment group receives their final grade after the preliminary grade leaves the local plant.
I would argue it's a rubber stamping process, because they present on the employees for 2 minutes, and then there's no record and evidence that any employee leaves with a different rank than they came in with. They always get the same, they get assessed at the same rank that they were preliminarily assigned. I would also say that there's evidence that Villatoro's demotion of her from a C to a D, even from 2018 to 2019, is evidence of retaliation, because he may not have agreed that she merited the Bs that she was receiving before, but the substantive criticisms were the same. And those substantive criticisms didn't change from 2018 to 2019, but the grade does. And we also see a close temporal connection between her protected activity and the ramp up in criticisms and the threats to terminate her. Villatoro and Sanchez were interviewed by HR pursuant to Ms. Ontiveros' complaint of machismo in December, and in January, Villatoro threatens to terminate her for the first time. And we have testimony from Sanchez that acknowledges you can't just fire an employee, you have to take them through the assessment process. So right there, the intent is relayed. Adverse actions that followed. So, and I also want to talk about the evidence that Exxon cites to in terms of where her performance issues. Villatoro's, what they point to, a lot of them are not in fact performance issues. You see that Villatoro emails her because he's concerned about a potential issue, so he wanted to preempt it. Or there was an issue that occurred, but the fault occurred from somebody, I believe, at the warehouse. It wasn't Ms. Ontiveros' fault, and that actually, she testifies to that, and that's elaborated in the email record as well. And so with that, I would say that there are genuine issues of fact as to how she was performing, how they were presenting her performance, and their intent to terminate her. Thank you for your time.
Thank you very much. Our thanks to both counsel. We'll take the case under advisement. And move to our third case this morning, United States versus Lester Crowder. Ms. Zostock.
Good morning, Your Honors. May it please the Court, Aaron Zostock for the appellant Lester Crowder. There's a single overarching legal question pertaining to all three of the issues that Mr. Crowder raised on appeal. The meaning that should be given to the phrase "not authorized by law to accept" in the subsection D of the bribery statute. So on appeal, Mr. Crowder raised that the government failed to prove him guilty beyond a reasonable doubt, that the underlying bribery statute that he was charged with pursuant to the Travel Act was unconstitutional, and that the court erred in failing to give a complete jury instruction regarding that not authorized by law to accept provision in the bribery statute. I'm going to focus mostly on the unreasonable doubt issue. However, I'm prepared to answer questions about all three issues, and they are very interrelated because they all rely on that same statutory interpretation issue. So first, there must be some separate underlying reason why Mr. Crowder's receipt of the funds from the FBI informant, Mr. DeZutter, was not authorized by law. That language is present in the statute, and the government's interpretation of that language and the
Did
district...
Mr. Crowder's counsel below agree not to give that part of the instruction?
So to me, that was unclear from the record. There was a very lengthy discussion about the jury instructions regarding the Illinois bribery statute, and the court recognized explicitly that defense counsel had objected to the instructions proposed by the government. However, it wasn't clear whether they objected in the exact way that was raised here on appeal. That exact argument, I do not believe is in the record, and I believe that it was thus forfeited and not waived. So it could be raised now, and but we did not waive it based on, I believe, even the most generous reading to the government shows that defense counsel did have objections to these jury instructions. It just was not articulated in the same way it was on appeal.
If we're in forfeiture land, of course, we're reviewing for plain error.
Correct.
So let's fast forward and say if there was error, and even if you make an argument that it was plain, you'd have to address first that third prong of plain error review about whether the outcome affected Mr. Crowder. I assume you're about to tell us why you would have been able to show, why Mr. Crowder would have been able to show that he was authorized or to receive these payments?
No, I actually disagree. That's actually putting the burden on the defendant to provide a defense at trial and to prove an element, a negative element of the offense. And it was actually the government's burden to prove all the elements of the offense. So Mr. Crowder's position is that if that element should have been given at trial and it was an error, that obviously did affect his substantial rights for the jury to be instructed as to all the elements that the government had to prove beyond a reasonable doubt. And that is a big problem because the essence of our judicial system is the government's burden to prove all the elements of the offense by beyond a reasonable doubt. And if the government did not, if the jury didn't even have an opportunity to consider this element, that seems like a very, very big error for Mr. Crowder on a trial. And there's no evidence in the record because the government did not believe that it had to prove that, whether or not they could prove it. I don't want to speculate whether or not they would be able to prove that or not because that's their responsibility, not Mr. Crowder's. So that also does tie into obviously very closely to the reasonable doubt argument where basically the government believes that Mr. Crowder's receipt of this money from DeZutter knowing that DeZutter wanted this payment to be a bribe, that in itself was enough to constitute this offense. However, that lends that not authorized by law portion of the statute to be completely superfluous and gives no meaning to that phrase whatsoever. And we can see that the legislation intended for it to have meaning because Section E does not include that language, not authorized by law to accept, and therefore it must be there for some purpose. And we do in fact have case law in Illinois that agrees that the statute requires two elements to be proven, which is first, the receipt of the property must not be legally authorized by law, and the defendant also must know that the property was tendered with that effect to influence somebody.
That element is treated as a legal question under Illinois law, and also as it incorporated into the federal statute that was charged here, and everybody agreed on that at the instructions conference, including defense counsel, that the instructions as prepared were acceptable on that score because that not authorized by law language in the Illinois statute was a legal question, that particular element. So there was no factual dispute that the jury needed to resolve on that. And it just wasn't, because he was a private person. He had no legal authority to accept this money. That was undisputed.
I actually disagree with whether
He was
or not
posing as a public official, but he really wasn't.
whether or not it was disputed, because there was a lot of discussion at trial by both sides about whether it was sufficient for the offense, for Mr. Crowder's commission of the offense, to merely just accept that money. Defense counsel's argument in closing was that was not sufficient. Defense counsel's argument in the Rule 29 motion was that was not sufficient, and there had to be something else legally for this to constitute him facilitating or promoting bribery.
I thought he signed off, defense counsel signed off on the instructions.
On the instructions, I believe my reading of that, it is very unclear because defense counsel objected to the instructions on the bribery offense, but I agree
on a different basis,
with you.
Not on
it was a
this
different basis.
So
yes,
that's not sufficient to preserve this argument.
So it was a different basis.
And once, counsel advances one argument, that's a waiver of any other argument.
I would say that it was unclear to my personal reading of that, because what the circuit court said, defense counsel has objected to these, and it was unclear to me with the amount of back and forth that was gone through on those jury instructions. If you read through it's several pages of discussion in the record, and to me it was unclear whether or not the fact that this was not legally authorized by law was something that the government had to prove. Defense counsel was very concerned about whether the government could argue that in closing or not.
It's kind of like a summary judgment issue where the facts are clear. It's just a question of whether the law applies. So I don't think it needs to be submitted to the jury as a factual issue. I don't see what's unclear about that statement. I think this makes sense based on the Illinois pattern instructions that mention this as a question of law. I don't know how that is subject to misinterpretation on appeal. He's waiving any argument on this issue.
So I would disagree, because that Illinois case law actually says that that's an element of the offense. So
If the facts are disputed.
If the facts are disputed, yes. And
That's
I think
when it
that jury
becomes an
instruction
element
should have
offense.
included.
But counsel said at the jury instruction hearing, and I'm reading from the transcript, based on the discussions the government and I have had over quite a bit of time on this, it is our collective opinion that there is not an issue of fact as to this.
As to what, though? I'm not sure.
This 4 lines up, he says, in regards to whether or not we should include not authorized by law.
Okay.
Pretty clear.
I'll concede that. I was very confused reading the jury instruction conference myself. I will say that I was unclear myself what counsel's objections were, and I was not trying to mislead the court in any way. I do, and that given that it is a legal issue, right, then the court should have considered it in the Rule 29 motion as a legal issue, and whether or not it had, the government had to prove that and show whether Mr. Crowder was not authorized by law to accept. And instead, what the court did, and what the government argues now on appeal, is that they argue that nobody can be authorized to accept a bribe. Now, that uses the word bribe, which is what we're defining, to explain who is and who is not authorized. The entire statute is trying to tell us as, citizens, and, you as the judiciary, what it is that what conduct is being prohibited.
Based on your reading of the statute, would it prohibit private individuals from being convicted of bribery?
It would depend on the circumstances, because in this circumstance, Mr. Crowder never actually intended to submit a bribe to anybody. So whether or not, he can accept money and mislead people, I do not think that that's prohibited by the statute in any way, shape, or form. He did not necessarily act legally, but he did not violate this particular statute. And that's the problem here, is, we can't we can't just say nobody can commit a bribe. That is completely
Well, that was
taking
just
out
shorthand. That wasn't a legal conclusion.
I understand that, but actually the government did argue that in their brief. They stated that the reason Mr. Crowder is guilty is because no person can be legally permitted to accept a bribe. That is what the government argued in their brief. And they said it multiple times. And that's the problem, is we have to look at what a bribe is. And a bribe is something that is given with the intention that it is, one, in this case, Mr. Crowder never intended to facilitate or promote bribery. He had his own intentions, and the government's evidence never contradicted his own personal intentions to never give that money to a public official. There's no evidence that the money went to a public official. There's no evidence that he met with a public official immediately
Well,
after.
he certainly talked a lot about giving it to public officials
He
to grease
did,
the skids for this strip club.
And his explanation for that was that he always intended to keep the money, and that is what the facts showed at trial, is that exactly what he did. And he intended to share it with another person who was also not a public official, Ramal Kellogg, who was the brother of the mayor, but also was not a public official.
If his admission that his plans, as he did on the stand, were to defraud Zutter, would that be unlawful activity that then brings him within the scope of the Travel Act, separate and apart from the issue of Illinois bribery? So, for example, if the court to hear does not go with you on Illinois bribery is an element of the offense that must be included and explained to the jury, et cetera, if we've just got garden variety fraud, do we have a Travel Act violation here?
I think if it's just garden variety fraud, it's a very close call because of the phone calls. The only way that the Travel Act was involved was through the phone calls to set up the meetings, phone calls or text messages. A majority of those were actually instigated by Mr. DeZutter himself, and he was the one that was using the phone to set up meetings with Mr. Crowder, and it was very incidental to the actual communications that they had. If you look at, the content of the communications that the government was concerned about, all of that was happening in person. The actual fraud and all Mr. Crowder's braggadocio about what he was going to do with the money was done in person. The exchange of the money was done in person.
So in other words, you're not contesting that Mr. Crowder admitted to fraud on the stand, and that is unlawful activity. You're saying the problem would then be now the interstate commerce element.
There is a problem with the interstate commerce element. A problem with the interstate commerce element that was raised in the brief about, that it's not sufficient. I wouldn't necessarily say that I guess he did more or less admit fraud on the stand, but he wasn't charged with committing fraud pursuant to the Travel Act. He was charged with committing bribery pursuant to the Travel Act. So there's a charge. I mean, if the government had also charged him with fraud pursuant to the Travel Act, I think, I might not be standing up here right now arguing this. I agree with that. And I think the problem for the government here is specifically the bribery statute, and that the fact that Mr. Crowder was charged under the bribery statute.
Thank you.
Thank you.
Mr. Kerwin.
Good morning, Your Honors, and may it please the Court. Brian Kerwin on behalf of the United States. I think I'll start, Chief Judge Sykes, with your questions about waiver, because it dictates whether the jury was properly instructed and therefore whether there was sufficient evidence to prove these violations of the Travel Act as charged in the indictment. Contrary to defendants' claim that there's confusion in the record, the record is crystal clear that the defendant conceded that there was no factual dispute on the question of whether he was authorized by law to accept money that he knew was tendered to influence a public official. That was said, I think, at least 4 separate times on pages 500, 501, 502, and 508. I think possibly one other time on 646 of the trial transcript. There was no factual dispute on that point. And in fact, defense counsel specifically asked the district court not to instruct the jury to decide that question. In doing so, the defendant both waived his challenge to the jury instructions, but he also waived his claim that there was insufficient evidence presented by the government on that point. And although counsel claimed this morning that it was an error by the district court not to assess that question as a legal matter post-trial, that argument was never made in defendant's post-trial briefing either. And so that is absolutely waived. But even setting waiver aside, the district court was right not to task the jury with deciding whether the defendant was authorized by law to engage in this conduct, because there is no law that authorizes it, as Chief Judge Sykes alluded to. And the Illinois pattern instructions, to Judge Pryor's point, state expressly that district courts or trial courts should not give this instruction unless there is a factual dispute. There was none. That takes us then to whether there was sufficient evidence for the jury to conclude that the defendant committed these charge violations of the Travel Act, and the jury was properly instructed that to convict the defendant, they needed to find that he used a facility of interstate commerce with the intent to promote or facilitate Illinois bribery, and thereafter took an act in which he performed or attempted to perform that facilitation or that promotion.
How do we, I guess, deal with what we've heard this morning in the contention that there might have been a variance?
If I understand your question, Judge Pryor.
Between fraud, bribery,
So I actually don't think that an act of fraud can support a violation of the Travel Act, because under section, I think it's B2, I have to look at the statute of 18 U.S.C. 1952, there's specific racketeering activities that are that fall under the unlawful activity category: arson, prostitution, bribery, among them. But the defendant here unquestionably promoted or facilitated an act of Illinois bribery as charged in the indictment, because under subsection D of that statute, all he needs to do is accept money tendered by a person that he knows was intended to influence a public official. And the jury heard at least 9 separate recordings of their meetings and their phone calls in which they discussed specific cash payments that would be made and then tendered to the second ward alderman in the city of Harvey, members of the Economic Development Committee. There was discussions of ensuring that police didn't give this hypothetical strip club trouble. All of that is squarely prohibited by subsection D of the statute. And
he's progressively upping the ante as I read the transcripts of the conversations, saying I need more for this public official, I need more for that public official, etc.
Correct, Judge. And that's why this is such a clear case, because he's not just facilitating or promoting an act of Illinois bribery, he's engaging it by taking the cash from the payor, knowing what the intention is because they're speaking it aloud.
And asking for more.
and asking for more.
So it's not like, I mean, this wasn't an entrapment defense because it was a government cooperator who was on the other side of the transaction, but, it's not like the cooperator was upping the ante, the defendant was.
I agree, and the defendant hasn't made that claim either. On this question, I believe Judge Pryor raised it as to whether private citizens can violate the Illinois bribery statute. Of course that they can. The plain text does not differentiate. The Illinois Appellate Court in both Friedman and Doherty decided that question, explicitly rejecting the argument that defendant has raised this morning.
It's the whole idea of a bagman.
That's right, Judge. The subsection D
It's very common bribery fact pattern.
Criminalizing being the intermediary between someone who wishes for a public official to be influenced, and the crime is committed by taking the money. And so I think that leads me to conclude with, just the fact that this goes to the core of what these statutes prohibit. There is no vagueness problem here, and the jury heard ample evidence for it to conclude that the defendant committed all the charged elements of the Travel Act and the elements of the Illinois bribery statute.
And what about the facility of the telephone? There was some discussion in the briefs as to whether or not the telephone qualified. Would you address that?
Yes, sure, Judge. The jury received an instruction that to convict the defendant of the Travel Act violations, it needed to find beyond a reasonable doubt that it used a facility of interstate commerce, not in an incidental or minimal way, but in a way that's significantly related to the underlying activity. And there was ample evidence for the jury to conclude that here, where the defendant used the phone for the sole purpose of setting up these meetings, where he then either solicited or agreed to accept or accepted these bribes. And so it's not a case where the use of a phone is somehow fortuitous or unforeseeable. This was his use of a phone for this very purpose. It related, as the district court said, in an integral way, and that's absolutely right. So unless the court has any additional questions for the government, I'll ask that the court affirm the conviction and sentence of the district court. Thank you.
Thank you. Ms. Sostock, you were almost out of time, but I'll give you some extra time in rebuttal.
Just very briefly, I wanted to address the government's argument that the reasonable doubt argument was not made in the Rule 29 motion, and it was made in almost identical fashion as it was made to this court. And reasonable doubt arguments can be made at any time. It did not need to be preserved at the trial court. It could have been raised right now, and it still would be preserved. I'm unclear why the government thinks a reasonable doubt argument is waived now at this point. That seems contrary to most case law that I'm familiar with, and the case law that was cited in the briefs. And again, the government has said again here that all Mr. Crowder needed to do was actually accept money, and then he had committed bribery. That's not the case. The statute requires more than that. The case law in Illinois has required that. There are conflicting cases to what the government has cited, and those explicitly say that both elements need to be satisfied. It's not just the receipt of the money. There is more to it. It has to be an unauthorized receipt. And I know Judge Sykes mentioned that the bagman situation is a very common fact pattern. However, I don't think that is directly imposed in this fact pattern, because
Right,
we
this
have
is a sting, yeah.
because well, not just a sting. So we have a masked intention on behalf of Mr. DeZutter. He never intended to open up a strip club, right? His intention was not to have charges charged against him.
Yeah, if that were a fatal flaw to this prosecution, then a sting in this context is impermissible as a constitutional matter. That can't be the case.
I think the problem is on both sides, though, right? We have Mr. DeZutter's intentions are flawed, right? He doesn't actually intend to bribe an official. That's not what his intention was. But also Mr. Crowder's never intended to promote or facilitate bribery of a public official. It's unclear.
Well, that was his defense. The jury rejected it.
The facts support that he never actually, and I don't think the government disputes that no government official was actually bribed by Mr. Crowder. So his intent is backed up by those facts. that he never intended, his testimony that he never intended to bribe anybody, he just intended to defraud someone out of their money. That is supported by the facts, and I do believe that makes it a problem on both sides as far as the intention. And with that, I'll just ask for this court to reverse Mr. Crowder's convictions or alternatively remand it for a new trial. Thank you.
Thank you very much. Our thanks to all counsel. We'll take the case under advisement and move on to our fourth case this morning. National Association for Rational Sexual Offense Laws versus Hughes. Yes, come on up, Mr. Weinberg.
May it please the court, this case is about the ability of an individual who is on mandatory supervised release to use erectile dysfunction medication while on supervision. An Illinois statute prohibits the use of erectile dysfunction medication. Plaintiffs contend that the statute violates individuals' substantive due process rights and Eighth Amendment rights, and sought to have the statute declared to be unconstitutional through Section 1983 action. The district court dismissed plaintiff's claim based on this court's decision in Williams versus Wisconsin, in which this court, based on Heck v. Humphrey, held that a condition of supervision must be challenged via a habeas petition and not via Section 1983. Plaintiffs are here today to ask this court to reverse the district court's dismissal of plaintiff's complaint. To do so, this court must either overrule or narrow its reading of Williams v. Wisconsin.
Before we get to that, would you address mootness, because your client completed his supervision?
That's true, Your Honor. He has completed his supervision. We don't think the case is moot because of the inherently transitory doctrine.
Before we get there, can I just get some, when did he complete his mandatory supervised release?
April 29th.
April 29th, okay.
Last month. We think that he meets all the conditions of the inherently transitory doctrine. He had standing when he filed the complaint. He filed a motion for class certification, and there is a large class of people that are subject to the same statute that interferes with their constitutional rights.
Did he challenge his underlying conviction?
No.
Can we go back to inherently transitory? Is the question before us whether, he filed his complaint, by my review of the record, about halfway through his period of parole. Okay, so at the 1.5 year mark, and he had 3 years to go. Is the question really for us whether anybody would be able to file a complaint and get to kind of the two prongs? You're saying, he needs to get to class certification and be able to pursue a 1983 claim. The other side is saying he needs to file a habeas action. Either way, whoever's right about what the particular law is, we know what Williams says. The question is, can anybody get through those steps within, say, a 3-year parole period? Is your position that nobody really could?
I think it's questionable. It obviously depends on bureaucratic conditions, how long it takes to go through, in a habeas case, how long it takes to go through the state court levels. There is another plaintiff in this case too, NARSAL, which is a national organization for reform of sex offender laws, and we think they have standing because many of their members are subject to this same restriction. So their claims are not moot. Now, we haven't named any other person other than the plaintiff Ridley, but there are people that we could name. Does that answer your question?
Well, none of this is kind of developed anywhere, because when the case was in the district court, his release date wasn't impending. It's been here for a while in briefing. So we don't really have any development of the main inquiry in the inherently transitory doctrine, which is whether any person's claim in this particular class that your client is seeking to represent would remain live for the duration of the suit. We don't really know.
I don't know if this is significant, but one of the reasons that he wasn't able to bring this in a timely manner is that the government got 4 or 5 extensions and delayed filing the brief for 6 months in this appellate court. So, but for that, he could have gotten through this process, but these administrative delays made it impossible to bring this claim in a timely fashion.
Right, but the inherently transitory doctrine looks at the proposed class and asks whether any person's claim within that class would suffice and remain live long enough to challenge this condition of probation or supervised release.
So there are definitely people that are members of NARSAL that would be able to bring this in a timely fashion.
So there are other plaintiffs available.
Yes, and
who could be substituted.
Yes, and
in a new action.
Yes,
Even though your client's claim is now moot, we're looking for this doctrine that you've asserted that saves this claim from mootness. But if there are other plaintiffs,
that could be substituted.
I don't know that.
Well, I mean, that are members of NARSAL, a plaintiff, and the reason that there's other plaintiffs is that they're not under the 1 or 2 year or 3 year MSR. They have lifetime MSR, and so these are members of the class too. I mean, of a potential class, and they're members of NARSAL, and NARSAL is a plaintiff here. So I think if the case were remanded, we would name the people in NARSAL whose claims are not moot. And if I'm understanding correctly.
Well, the problem is none of this is really developed. And we've got just, like 2 paragraphs from you and 1 paragraph from the state actors here on mootness, which is a pretty skinny record on which to make a decision about mootness. We may need supplemental briefing on this.
Happy to engage in that if the court wants it. As far as asking for this court to overrule Williams, there are 4 reasons that we believe Williams should be overruled. The first and the most important is that Heck only prohibits a constitutional challenge via 1983 when a favorable judgment would necessarily imply the invalidity of the individual's conviction or sentence. And here we are asking for this, finding a condition of supervised release unconstitutional would not in any way imply the invalidity of the underlying condition or sentence.
Well, it's an attack on the sentence because conditions of release are part of the sentence, whether they're mandatory conditions imposed as a matter of statute or discretionary conditions imposed by the court. They're all part of the judgment of conviction and part of the sentence. So it's an attack on the sentence.
I would see it, I guess I have 2 responses to that. One is it's a means of affecting the sentence. The sentence here is supervision.
Not just supervision. It's supervision plus all the other conditions that are in the judgment, which include all the statutory conditions, and this one included.
So I agree.
It's not like a conditions of confinement suit by a prisoner for a random act of a prison guard or another inmate, etc.
So I think that sentence has been interpreted by the Supreme Court in Wilkinson v. Dobson as meaning duration, not meaning duration of the sentence, not meaning every condition of the sentence, A, but B, our belief is that the individual would still be under supervision even if one of the conditions were found to be unconstitutional. And so while it's modifying the terms of the supervision, it is not in any way undermining the sentence itself. On that point,
You're seeking relief. Your client is seeking relief from a condition of his supervision, which is a challenge to his sentence.
well,
Because it's part of his sentence.
it's a means, and I think that Supreme Court in a recent case, 2022 case, Nash v. Ward, is the strongest case for us that challenging a means of affecting a sentence is not affecting
It's not a means of affecting the sentence. It's part of the judgment
the
that
sentence.
he has to comply with this condition
Well, I guess
because the statute says so.
I think a bigger question for you is, I mean, I think a case like Thornton from the Ninth Circuit shows reasonable minds can disagree about some of these issues, okay? But as a circuit, we have to overcome our inclination not to overturn circuit precedent, and you have to provide compelling justifications.
Right, and I think that there's been intervening Supreme Court cases that suggest that challenging a condition of supervision is not challenging the sentence. And the best case I think for that is Nash, as I said, Nash v. Ward, in which a Georgia prisoner was sentenced to be executed, but he challenged via 1983, and the court said it was okay, the means by which that execution was to occur. And the court said, you're not changing the sentence, you're just challenging the means. In this case, it was a lethal injection means that caused pain. And so in the same way, I think by analogy, we are not challenging the supervision. This person will still be under supervision, but we are saying that the means of the supervision, one of the means is unconstitutional. And really here, all we're asking is that there be an individualized determination of whether a person can use erectile dysfunction. This is an absolute prohibition. I see my time is up. The court doesn't have any questions? Okay. Thank you.
Thank you. Mr. Rush.
Good morning, Your Honors. I'm Assistant Attorney General Caleb Rush, appearing on behalf of Defendant Appellee LaToya Hughes, the Director of the Illinois Department of Corrections. This appeal cannot succeed for three reasons. First of all, plaintiff's claims are moot. Second, the precedent of Williams versus Wisconsin should be upheld. And third, plaintiffs have failed to state a claim of any constitutional violation. Each of these reasons is an independent and sufficient basis to affirm the district court's dismissal or to dismiss the appeal. I'll start with mootness. It's undisputed that Mr. Ridley's MSR or parole term is complete, and he has only argued one exception to mootness, which is the inherently transitory exception. We need to be clear about what the legal standard for this exception is, because he cannot meet the first requirement for this exception. It's not about the duration of litigating the entire case. The inherently transitory exception is about, is it uncertain that any member of the proposed class could even maintain a live controversy long enough for a judge to certify a class? That's quoting from this court's decision, in Olson versus Brown. In Olson versus Brown, this court talked about a 90-day duration, 120-day duration. That's not what...
This exception to mootness, or it's really not an exception to mootness, it's a way of saving a claim from mootness in the class action context.
Yes.
It's ordinarily applied in the pretrial detention context when prisoners are, or I shouldn't say ordinarily, that's the most frequent iteration of it. When jail detainees are only in jail for a period of a couple of days to maybe a couple of months at most. And so it's that nature of that kind of detention that makes the inherently transitory doctrine or puts it into play.
Exactly, Your Honor. And here what we're talking about is MSR conditions.
So if we accept that they're out, that Mr. Ridley's claims are out, is the National Association's claims moot as well?
At that point, NARSOL would have no standing because they have not ever identified to this court anybody who would have standing. And NARSOL only would have potential standing through members, associational type standing.
Say it one more time, the last thing you said, I couldn't make it out.
I'm sorry, Your Honor. That NARSOL's only, NARSOL's an association. It would only have standing through a claim by a member.
Well, two different things. Associational standing is one thing, third-party standing is another. And the problem here is we don't have briefing on any of this stuff, and so it's a little hard to evaluate because it hasn't been briefed or argued. I think we're going to need supplemental briefs in this case. But to the response that you just gave Judge Pryor, associational standing is something different than third-party standing. And I'm not quite clear on what the plaintiff's argument is with regard to this National Association for Rational Sex Offense laws. That they've talked about having other plaintiffs that they can substitute in, but there also seems to be some sort of a claim of associational standing lurking under the surface, and I'm not quite sure. Those are different things.
I'm sorry, Your Honor. The fundamental point when it comes to the inherently transitory theory on mootness is this the type of claim where nobody is likely to have a claim that lasts long enough to rule on a class certification motion, 90 or 120 days? That's not this type of claim. We're talking about MSR terms under Section 5-8-1 of Illinois' MSR statutes. For Mr. Ridley's offenses, the MSR term is a mandatory minimum of 3 years up to life.
I think the Olson case he identified was also 3 years. It was a different situation, but it was a 3-year term that was at issue. But I want to move on from mootness now because I think there's indication from the bench that no matter what you say, the court is going to want to know more, and we deserve to know more on that important question. I want to ask you, how do you explain the district court's decision to dismiss with prejudice here? Everybody's highlighted Williams as the key case to pay attention to, and we said pretty clearly in Williams, although we didn't abide by it ultimately, but we did say these dismissals need to be without prejudice because the plaintiff needs to go file a habeas petition.
Yes, Your Honor. If this case is not moot and if it's disposed of purely on the rule of Heck and Williams, then the dismissal should be affirmed, but it should be modified to be without prejudice. Okay. Now, on that issue of reaching the merits, and I'd like to return to the Williams precedent in a moment, but on that issue of reaching the merits, this case, like Williams, is an appropriate case to actually reach the merits and affirm the dismissal with prejudice. The merits were fully briefed below, contrary to the misstatement in the reply brief. This court has gone beyond threshold issues to address the merits in cases like Williams, also in the case cited in our brief, Jones versus Cummings. And there's a fundamental principle at stake here that the plaintiffs should not be allowed to unilaterally prolong unmeritorious litigation by just choosing not to support their case. For other issues on the merits, we stand on our brief. I'm prepared to answer questions, but I'd like to return to this question of the Williams precedent. There's no basis to revisit this precedent. There might be a basis if Williams was an outlier. It's not. The plaintiffs don't even argue that it is an outlier. 3 other circuits have stated that habeas is the proper avenue to challenge parole conditions. Yes, the Ninth Circuit in Thornton reached a different result, but the Ninth Circuit itself said that its result was consistent with Drollinger and Williams in this circuit because the parole condition at issue in that case, the Ninth Circuit determined was not part of the sentence. It might also be appropriate to revisit Williams if it worked a substantial injury, but it does not qualify for revisiting precedent in that sense. Mr. Williams could have litigated this case in state court starting in 2018 when he had cancer and when he had complications resulting from treatment. He could have litigated this case more than 3 years ago when his MSR or parole term started. The Illinois post-conviction statute allows people to introduce new evidence to raise a theory that wasn't raised at trial. There's no special constitutional entitlement to a counsel or attorney's fees in this process, even though counsel for indigent defendants is provided under the Illinois post-conviction statute. Also, the plaintiffs have not identified any sex offender who has attempted to challenge Section 7.10 through state remedies or through habeas. There's simply no working of a substantial injury here. And then the final point that I'd like to make is that Williams was correctly decided. It's compelled by the rule in Prizer and Heck. And that rule is whether a claim would invalidate a conviction or sentence in whole or in part. It's clear that this parole condition is part of Ridley's sentence. This is not like the Nance versus Ward case, which was about the method of carrying out capital punishment. The Illinois statute, as the court is aware, the Illinois statute says that the parole condition is part of the sentence. And plaintiffs have not disputed the case law that says that seeking to invalidate even part of a sentence will invoke the Heck bar. I would note that plaintiffs' view of this would invalidate not just Williams, but also Drollinger, this court's precedent going back to the 1970s. And so for all these reasons, we ask this court to either dismiss this appeal or to affirm the district court's dismissal, and we will be happy to submit supplemental briefing on mootness.
Thank you. Mr. Weinberg, anything further? You had run out of time. I'll give you a minute if you'd like to respond briefly.
I'll respond briefly. I guess most importantly, if the court wants it, we'd welcome the opportunity to brief the issue of mootness. My friend said that the merits of this case were briefed fully below. They were not. Obviously, this was a motion to dismiss. My friend suggested that we had time to rule on the class certification motion. We didn't. This case was dismissed promptly. We filed the class certification motion, but there was no briefing on it. And this case, I think Williams is an outlier if the court actually looks at the case law out there. No other case, they've had 20 years. Well, Williams decided in 2003, no other case in 22 years has agreed with the logic of Williams. Thank you, Your Honors.
Thank you very much. Our thanks to all counsel. We'll take the case under advisement. And our next case this morning is Kathleen Hayes versus the City of Chicago Board of Education. Ms. Seaborn.
Good morning, Your Honors, and may it please the Court. My name is Erica Seaborn, and I'm here representing the Board of Education and Mr. Lyons. I'd like to start with the jurisdictional issue because that is a threshold inquiry and it was the basis of the motion for sanctions. This appeal is a proper use of the collateral order doctrine. The case is most like the Supreme Court case in Plumhoff, where the defendants did not deny that they had committed the conduct. The only question that they brought on the appeal was contesting whether the law against it was clearly established under the second prong of qualified immunity. And that's what we're asking the court to do here. We are not asking the court to determine any factual dispute, including the factual disputes that were identified by the district court on summary judgment. We're asking the court to rule on whether there is clearly established federal law that was violated, assuming the facts in the light most favorable to Hayes in this case. So that is a permissible use of the collateral order doctrine, so the court does have jurisdiction over the appeal. I'll move on to the qualified immunity question. It was Hayes's burden before the district court to disprove qualified immunity and to bring forth clearly established federal law for that second prong. The district court did not hold her to that burden. Throughout summary judgment and in the briefing in this court, Hayes has focused on the first prong of qualified immunity, the constitutional violation. But while a constitutional violation is necessary to defeat qualified immunity, it's not sufficient. You need the second prong as well. And for the purposes of this appeal, we're only looking at the second prong. So Hayes could have shown the second prong either by identifying a body of precedent or by showing that the constitutional violation was obvious. But she didn't show it through either option. In terms of the precedent, it's not enough for Hayes to rely on general statements about the First Amendment. Reichel v. Howard's laid this out in the Supreme Court. So it's not enough for her to say the First Amendment prohibits government officials from retaliating. That's just too general. In order to succeed for qualified immunity, she needs to particularize the right. It has to be specific enough that a reasonable public official would know what conduct is prohibited and what conduct is allowed. The cases that she relies on, however, are cases like Bantam Books and Backpage, where the factual scenarios are so far removed from what was going on in this case that they cannot have provided any guidance. And because of that, they have no factual commonalities. They only end up relying on those very general statements about the First Amendment.
Because we're moving it out of kind of the employer context to this non-employer context, I wanted to know, from reviewing the record, wasn't quite clear the relationship between Northwestern School of Education and Chicago Public Schools. Is there a contract? Is there a...
Your Honor, I would have to go back and look at the record to see exactly what terminology is, and I might be able to get you more information for rebuttal. I can tell you that Ms. Hayes was not a public employee. She did not work for CPS. She worked for Northwestern. She identified herself on summary judgment as
Chicago Public Schools.
Yes, CPS as Chicago Public Schools being the entity that the Chicago Board of Education governs. On summary judgment, if you look at her summary judgment pleadings, and that would be document 80 and document 88 in the district court record, she refers to herself as a private sector person, and she refers to Northwestern as a private employer, which they are. So to the extent that there is any relationship between CPS and Northwestern, she did not...
Every time you say CPS, I have to remember what those initials stand for and not CPS, as I'm accustomed. So if you could just keep it to Chicago Public Schools, because I get distracted every time. I'm sorry.
I understand. That's a common area of confusion for us as well. But since she was not an employee of Chicago Public Schools, she never alleged that she was. And in terms of the qualified immunity, she never alleged that there was clearly established federal law that applied to her as being a non-public employee. That was not the strategy that she took in terms of trying to present the clearly established federal law. There's clearly established federal law about public employees, but she did not bring that law to the district court and say this is the body of law that controls the second prong of qualified immunity. So, in terms of the second prong of qualified immunity, she also could have tried to show this through obviousness by showing that the conduct was patently violative of the Constitution, but she didn't really attempt that. The district court didn't rule on it, and the situation just does not fall into those very extreme fact patterns. So again, it was Hayes' burden to defeat qualified immunity by showing the second prong, and she just did not do so. I'll briefly touch on the sanctions motion. It should be denied. Rule 38 is meant to deter frivolous appeals. This one is not. So if the court has no other questions at this time, I'll reserve the remainder for rebuttal. Thank you.
Thank you. Mr. Persoon?
Good morning, Your Honors. Michael Persoon on behalf of Kathleen Hayes. The law is pretty clear. The government and reasonable government officials, including Matt Lyons, should know that you can't do indirectly what you can't do directly when it comes to the First Amendment. You can't retaliate against someone because of their speech.
That's at a very high level of generality. You have to make it more specific to this case in
Oh.
order to overcome qualified immunity.
We looked at, there's a technical aspect that you're talking about where we want to have this very clear statement that would put someone on notice. And there's a practical aspect too. But to directly answer your question about the technical aspect.
It's
we-
actually not a technical, practical distinction. It's a legal rule.
Yes, Judge. Bannon Books is a good place to start in 1963. There you had an agency that didn't have any regulatory power, and it was sending out, it was engaged in government speech. It was using that speech to discourage other speech.
Right. The Bantam Books case and the more recent case of National Rifles Association versus Vullo established, in our iterations of the general principle, neither of them is comparable to what the facts in this case are. So what you need to do to overcome qualified immunity is to identify a case with factual similarities to this case that would have put Mr. Lyons on notice that his emails to Northwestern notifying the university's education school of Ms. Hayes' conduct or postings on Facebook those emails were coercive of Northwestern to punish Ms. Hayes for her First Amendment speech by firing her. So it's a question of coercion.
I agree, Judge.
And you haven't identified any cases that are at least factually similar to this one that would have put Mr. Lyons on notice that by notifying the university in the very diplomatic way that he did, he was coercing the university to punish your client for her Facebook speech.
In trying to listen very closely to your question, Judge, what I keyed in on is a fact question. Was Lyons' speech coercion? I think there is a legal rule, Bannon Books, back pages, and as Volo decided after this case, but in saying Bannon Books
Actually,
is
the
enough.
question of the sufficiency of the evidence at summary judgment to create a material issue of fact is a legal question, and the qualified immunity question is entirely a legal question.
As we briefed, Judge, the district court made a finding that there was a fact dispute that necessitated.
Right, and we're not bound by that. We can look at the record and determine whether there's a legal question here on qualified immunity.
I just note, Judge, that the district court's finding that there was a fact dispute is
The
non-reviewable.
district courts make no findings on summary judgment. They're not fact finders. Even if he used that language, Judge Ness used that language, it's not a factual finding. It's all about the sufficiency of the summary judgment record to create a triable issue of fact under the applicable legal standards, or whether either on the merits the defendants are entitled to judgment as a matter of law, or on qualified immunity. The qualified immunity shield has been pierced by you. They have no burden to establish qualified immunity. Once asserted, it's your burden to overcome it.
On the question, Judge, on qualified immunity, I think that when we look at Bannon Books, back pages, when we see even the Hutchins case, it says that when there is a threat, the Hutchins case that was cited and that the district court cited.
Right, that's the legal principle. There isn't anything in this case that even remotely resembles the fact patterns of those cases. And so for qualified immunity purposes, you need to come up with a case, point us to a case that is at least within the zone of yours in order to demonstrate that Mr. Lyons was on clear notice that his emails to Northwestern were unconstitutional.
I'll use the facts from the back page case as we brief them, Judge, that I think is very similar and is on point and goes well beyond the level of general applicability or broad principles. If you recall in back page, Sheriff Dart, probably doing some really good work and some innovative governing, wrote a letter to Visa and MasterCard saying that as a sheriff and as a father, he wanted to bring to their attention that Backpage was running ads for prostitution, basically. And the district court decided that that didn't state a claim and that there wasn't a First Amendment violation. It's a well-reasoned opinion by a respected judge. This court disagreed. And in noting their disagreement, they said, it doesn't matter that Visa one of the people who was shook down, so to speak, actually put a declaration in the record saying that they weren't threatened. What this court looked to was the actual conduct, the timing. Sheriff Dart sends this letter, which on its face denies that it's a threat. Visa denies it's a threat. And he sends a letter in response to speech. And it says,
Sheriff Dart was threatening criminal prosecution.
he was,
Nothing remotely like that happened in this case.
he wasn't threatening
Mr.
criminal.
Lyons was very diplomatic, said this is not a termination-worthy event. It was concerning, but he left it completely in the university's hands about what to do with it and expressly said that. And then after that, just responded to the university's requests for information.
My recollection of back
There is
page-
nothing in this email exchange that comes even close to any kind of a threat.
He testified that his purpose in sending the letter was to make the speech stop. And look at what the speech that he wanted to stop was. One of the speeches, which was also association, was Kathleen Hayes posting on Facebook, let's get the more government oversight of CPS because they're not doing a good job on sex offenses.
Let me zoom out a bit. What kind of letter could Lyons have written from Dr. Hayes' perspective that would not have given rise to First Amendment concerns?
He could have written a letter saying, I don't know what his legitimate purpose in sending this letter is. If he had a letter that was critical of her conduct in her role, this isn't talking about she's not doing a good job as a partner in placing CPS students. Those students were continually being placed. He wrote a letter coming after her because of her private speech. So if he wants to write a letter, the letter he could write is say, we're in a partnership, really important partnership to get student teachers into CPS. And Kathleen isn't doing it. Kathleen's not doing it. In fact, she's steering people away. And here's the proof. But what he shouldn't be doing is sending letters that says, Kathleen Hayes is a registered Democrat. Kathleen Hayes is a registered Republican. Kathleen Hayes donated to Planned Parenthood. Kathleen Hayes donated to the National Rifle Association. He's targeting her. What he shouldn't do is complain to her employer about her speech, and in doing so, bring in the quote, importance of the relationship. I know you know where I'm coming from. These are direct quotes from Matt Lyons in his email that we put in our statement of the case. I know you get it. This extended dialogue back and forth. And clearly, Northwestern got the message. They said, we apologize. We know the importance. Our response will be swift. I've already talked to the general counsel's office about this. This is an employee who, the person who made the decision to fire her, had personally reviewed her as only excelling. And within 3 days of getting the email from Matt Lyons complaining about her public protected speech and protected association, he's asking to fire her. That's where that brings that right into back pages, where Sheriff Dart raises this issue of concern. As a father, I'm writing you, Visa.
But he says in that case, cease and desist.
It was a request.
There was a threat of, well, we found in Backpage, there was a threat of criminal prosecution, asking to cease and desist.
As a fact. And coming back to what I was trying to argue, I really think that what's on appeal here is the fact question. What Matt Lyons has always argued is that he didn't make a threat. He didn't have any authority. And the district court found that there was a disputed fact, and I'm sorry about that.
But he has accepted for purposes of this interlocutory appeal that we accept that my email was a threat. There's no clearly established law, though, that put me on notice that I could not send that email.
If he truly accepts that this was a threat, I think that answers Judge Sykes' question to me. If he truly is here on a pure legal question, says, we accept that this was a threat, then Backpage is right there, Hutchins. I can read from Hutchins. This is talking about...
Unqualified immunity, the defense doesn't have to accept that this email exchange constituted a threat. All the defense has to do is to accept that the inferences can be drawn, even assuming the inferences can be drawn in your client's favor, the constitutional violation was not clearly established here. That's how qualified immunity works. They don't have to say, yes, I made a threat. All they have to do is assume for purposes of the argument that inferences could be drawn in your client's favor. And that's setting aside whether this is really a legal question or a factual question, but we don't have to get into that now. It's really a question of the sufficiency of the evidence to establish a constitutional violation in the first place, which is step one of qualified immunity. But even if they're not relying on step one and only relying on step two.
I see I'm out of time, Judge. Thank
Yeah.
you for your time.
Thank you. Ms. Seaborn, anything further? Let me just ask a question at the outset here. Are you relying on step one of qualified immunity analysis? Are you
No.
arguing the merits about whether there's a constitutional violation here? Or
No.
actually the evidence is sufficient to establish a constitutional violation?
No, we are not arguing about the first prong of qualified immunity at all. So all of the factual disputes that counsel spoke of or that were identified by the district court, we will deal with those when and if we get back to the district court. That will be the place to get into whether or not Mr. Lyons had the intent and what exactly the text of those emails meant. So for purposes of this appeal, we are limiting this to the second prong of qualified immunity.
It's an unusual strategic choice, but it's yours to make.
Yes. Judge Pryor, in terms of your earlier question about the business relationship.
I just wanted to, I was going back through the brief, I'm sorry, to make sure that you did accept prong one. You're only arguing prong two.
We are only arguing prong two.
Okay.
For the purposes of this appeal, we'll, assume the facts as they were presented.
Okay.
We'll deal with prong one once we get back to the district court and we're in front of a trier of fact. In terms of your earlier question about the business relationship, if you look at document 87, which is one of the summary judgment pleadings, pages 5 and 6 discuss the partnership, quote unquote.
Document 87?
Document 87, pages 5 and 6. That's where they discuss the details of the partnership between Chicago Public Schools and Northwestern. My colleague informs me that there is a contract, but the text of that contract is not in the summary judgment record. So if that's something that you're interested in, we might be able to produce that in a 28J letter or supplemental briefing.
Thank you.
If the court has no other questions, we would ask that you reverse the district court's judgment on count one and deny the motion for sanctions. Thank you very much.
Thank you very much. Our thanks to both counsel. The case is taken under advisement. And we'll move to our last case this morning, Michael Lincoln versus, I guess it's now Frank Bisignano. It's the commissioner, acting commissioner of Social Security. Mr. Schiff, good morning.
May it please the court, Jim Schiff on behalf of the plaintiff Michael Lincoln. This is a Social Security disability case in which the administrative law judge made several errors. We are contending that the administrative law judge failed to weigh evidence pertaining to Mr. Lincoln's use of a cane for ambulation and balance, as well as fatigue resulting from the medications used to treat his prostate cancer. We are also contending that the ALJ failed to follow the requirements of 20 CFR 404-1520C in evaluating the supportability and consistency of nurse practitioner Jackson's opinion. And finally, we are contending that the ALJ's evaluation of Mr. Lincoln's symptoms was patently wrong. In this case, the ALJ ignored significant evidence establishing that Mr. Lincoln required a cane for ambulation and balance, and his failure to consider that evidence directly affected the outcome of this case. If the ALJ had found that he required a cane for ambulation and balance, he could not return to his past relevant work as a bus driver as he performed the position, and a finding of disability would result. Social Security ruling 96-8P states that the ALJ's residual functional capacity finding must be based on all relevant evidence in the case record, including medical signs and laboratory findings, recorded observations, and medical source statements. The ALJ mentioned Mr. Lincoln's reports to the consultative examining physician in 2020 that he used a cane occasionally for balance while arising from a seated position. And the ALJ also referenced a March 2022 exam where Mr. Lincoln was observed to use a cane. But the ALJ did not discuss examinations from March, May, and August of 2021 where he was observed to walk with a cane, and in particular, the August 2021 examination showed not only that he used a cane, but his balance was unsteady without it. This evidence the ALJ did not discuss undermines his conclusion that there was, quote, no indication that Mr. Lincoln required a cane on an ongoing basis. While an ALJ is not required to discuss every piece of evidence, he could not ignore an entire line of evidence that is contrary to his ruling, and we are contending that that is what happened here. The 2021 examinations the ALJ failed to mention establish a pattern of cane use, and if the ALJ had considered this evidence, he may have found Mr. Lincoln incapable of returning to his bus driver position and light work in general. The bus driver position required him to lift the hood of the bus for inspections and open and close cargo doors. A person who relies on a cane for balance would not be able to use both arms to perform these actions. The ALJ also acknowledged that Mr. Lincoln's fatigue reasonably arose from his cancer treatments, but found that his fatigue would still allow him to perform light work because he did not appear to undergo treatment specifically for fatigue. But the ALJ was mistaken on this point, as his oncologist, Dr. McVicker, advised him to maintain good nutrition, hydration, and exercise. And the agency recognizes these methods as treatment under the ruling, Social Security Ruling 16-3P. The ALJ must consider treatment other than medication the individual receives or has received for relief of symptoms in evaluating the intensity, persistence, and limiting effects of the claimant's symptoms. The ALJ did not comply with the ruling in this respect because of the way Mr. Lincoln described how his fatigue affects him, which was that it interfered with his ability to stay awake. He required a 2 to 3 hour nap every day. He was precluded from standing for more than 15 minutes at a time, and he had difficulty driving a car. And there's testimony in this case the ALJ did not evaluate, in which he stated that he has trouble maintaining a driving position, staying in the correct lane, that his wife was always yelling at him for swerving in and out of lanes. And importantly here, the judge found that he could go back and do a position in which he is expected to transport students safely to and from school and sporting events. So any interference with his ability to drive is certainly relevant in this case. We are also contending that the ALJ did not comply with the regulation in evaluating the opinion of nurse practitioner Jackson. And one of the things that the ALJ drew an incorrect conclusion about was the ALJ said that the opinion seemed to be based on statements Mr. Lincoln had given to Nurse Jackson as opposed to objective evidence. But Nurse Jackson clearly identified support for her opinion on the opinion form itself. She stated that objective evidence supporting it was hardness at the left base of the prostate, a PSA level of 35.8, and a prostate biopsy that showed prostate cancer.
Well, his cancer diagnosis is accepted.
Correct.
By all, including the ALJ here. So the fact that the nurse practitioner, who's the only one apparently whose report favored a finding of disability, the fact that she noted his cancer diagnosis doesn't really move the needle.
Well, Your Honor, in addition to the actual objective findings, the laboratory findings, the nurse did identify his symptoms. So
as reported by him, which is what the ALJ said, that she relied heavily on his own reports rather than any other objective or clinical evidence of fatigue, ambulation problems, etc.
Well, this is an interesting situation because the administrative law judge credited the fact that he would have fatigue from the cancer treatments, but then said that there's other evidence that the fatigue would not limit him or preclude him from performing a bus driver position. But once she credited the existence of the fatigue, she had to look at once he credited the existence of the fatigue, the administrative law judge had to consider what are the resulting work limitations from that fatigue. And that's where the ALJ's analysis stopped. The judge did not consider, well, if someone's fatigued, do they have to take a nap? Are they going to be having issues with concentrating or paying attention to the road? And in this case, the administrative law judge also found that Mr. Lincoln had mild limitations in concentration, persistence, or pace, solely resulting from depression and anxiety. So when you combine the fatigue that results from the cancer treatments and the fatigue and the limitations resulting from the mental impairments, you have a picture of someone whose fatigue caused significant work-related limitations the ALJ did not account for. In addition, in this case, the ALJ found that Mr. Lincoln's symptoms could not be accepted as consistent with the record because he only occasionally complained of fatigue. And we submit that that was inaccurate because Mr. Lincoln complained of fatigue or tiredness at 21 separate medical visits to 5 different doctors and physical therapists. So from this decision, it is not clear what the ALJ was expecting in terms of Mr. Lincoln's complaints. What frequency of complaints would have better substantiated his allegations? And so we are contending, based on the 3 errors I identified, that the administrative law judge's decision was not supported by substantial evidence, and this court should reverse. I'll save the remainder of my time for rebuttal. Thank you.
That's fine, thank you. Mr. James.
May it please the court. Good morning, Your Honors, Mr. Schiff. Your Honors, I'm Daniel Robert James on behalf of the Commissioner. Your Honors, this case had not only an initial review and a reconsideration review, but a special third assessment called a quality review. And in those assessments, all 3 doctors reached the same conclusion, agreeing that Lincoln could perform light work. The ALJ adopted this conclusion. The ALJ presented this light work hypothetical to a well-credentialed vocational expert who justified indeed that Lincoln could not perform his more taxing work as a truck driver, but that he could perform his past relevant work as a school bus driver. In making these findings, the ALJ considered the whole record, including that Lincoln suspected he might have cancer and unfortunately tested positive for cancer. But Lincoln quickly began treatment, and thankfully his conditions improved. Several months into treatment, his prostate-specific antigen levels were normal, and his condition was relatively stable within a year. The ALJ noted that during this treatment that Lincoln was active. The ALJ pointed to household chores and caring for pets. In February of 2020, Lincoln reported that he spent 90% of his day running an eBay store, and in June of 2020, he mowed 2 acres. The ALJ reasonably discounted Lincoln's statements based on these inconsistencies. The chief argument made by counsel is that Lincoln required a cane and that he used this cane whenever he left the house, but that simply was not borne out by the record. The ALJ properly found instead that Lincoln did not consistently use a cane on an ongoing basis. Indeed, there were significantly more occasions where Lincoln showed a normal gait or normal findings than there were when he used a cane, and cane use was not consolidated to one single point in time. It was throughout the record. He would have a normal gait. He might use a cane 1 month and then followed 2 months where there was a normal gait.
Can I interject and ask you something that was not anyone's focus, but there's the ALJ at a certain point notes that Nurse Jackson found that Mr. Lincoln was likely to be absent from work about four days per month on average as a result of his treatment or impairment. Whatever happened with that piece of information? That's once a week.
Yes, Your Honor. The ALJ considered that and considered the other findings of Nurse Jackson as well, which were very extreme in comparison to the other opinions, including that Lincoln could sit less than 2 hours, that he needed to lie down throughout the day. And the ALJ gave valid reasons for breaking with this opinion. First was that Nurse Jackson conflicted with every other doctor of record. As mentioned, there were 3 reviews, and all 3 doctors found that Mr. Lincoln could perform light work, while Nurse Jackson disagreed and found that he could perform not even sedentary work, well below sedentary with the absences that Your Honor mentioned. Nurse Jackson's opinion was inconsistent with Lincoln's own statements. Nurse Jackson said that Lincoln could lift only 10 pounds, and the very next day, Lincoln told his consultative examiner that he could lift 20 pounds. Nurse Jackson clashed with the treating doctor who was treating Lincoln's primary care physician over a handicapped parking placard. where Nurse Jackson said he qualified, but Dr. Dumitrescu found clearly that he did not. So the ALJ faced a predicament where it was to either go with the 3 consistent opinions with the record, or to break with those 3 opinions of the doctors and go with Nurse Jackson when Nurse Jackson was inconsistent internally. As the ALJ pointed out, notes from that same day when Nurse Jackson gave the opinion, her examination was relatively normal and didn't contain the type of findings that would be consistent with 4 monthly absences, as well as Lincoln's own statements and the opinions of the other 3 doctors. The same that was true with the cane is also true of fatigue, where as opposed to making consistent claims of fatigue, Lincoln regularly told his doctors that he was up and active each day. At times he said even though he had fatigue, it did not interfere with his daily activities. He reported baseline energy at times, and he told doctors that his anemia improved with treatment. And what this breaks down to is the substantial evidence standard of review. Here we need to show that a reasonable fact finder could agree with the ALJ, and certainly the opinions of 3 doctors coupled with Lincoln's activities and his spending 90% of his day running the eBay store and mowing 2 acres was enough to back the ALJ's decision, and we argue that it was.
Here we have a case where the ALJ was more persuaded by the kind of consistent opinions by the non-examining physicians, as opposed to this nurse who actually saw Mr. Lincoln. Now, a layperson may think that the person who examined, the medical professional who examined the claimant, their opinions ought to have more weight. But that's not quite consistent with our law, is it? Our case law.
That's correct, Your Honor. The law actually somewhat recently changed, where I think it was 2017. We used to favor the treating status over the examining or reviewing status. Now, the 2 factors that are most important are supportability, meaning the doctor or nurse makes a statement and how well he or she supports that with citing to evidence, and then the consistency with the overall record. And here the ALJ pointed out that Nurse Jackson's opinion lacked both. The same day that she said that, as Your Honor mentioned, 4 absences, the findings from those notes were normal. There was nothing really that stood out in those notes with a normal examination. The same was true of consistency. You have 3 opinions from 3 doctors who reviewed the record at different times, and her own conclusions conflict with those of Lincoln's statements, saying Nurse Jackson finding that he could lift only 10 pounds, and Mr. Lincoln telling the consultative examiner that he could lift 20 pounds. And Nurse Jackson also clashed again with the treating doctor over the handicap placards. So based on all those, the ALJ decided to go with the opinions of the 3 doctors who were consistent with one another and were consistent with the evidence and Lincoln's activities over that of Nurse Jackson. And unless Your Honors have any questions, we ask that you affirm the decision. Thank you.
Thank you. Mr. Schiff, anything further?
To respond to the Commissioner's points, I want to first alert the Court to a change in administration policy. As of June 2024, the Social Security Administration is now considering work done within the last 5 years of the date of adjudication or 5 years of the date last insured as past relevant work. If this case were remanded, Mr. Lincoln is virtually certain to win the case because he last performed the school bus driver position in November of 2011, which is well beyond the 5-year look-back period the agency now considers relevant. Also, to respond to the substance of the Commissioner's argument, the Commissioner is ascribing a lot of analysis to the ALJ's decision which did not actually take place. All the administrative law judge said about the state agency opinions was that they were consistent with each other and they were consistent with the post-reconsideration production of evidence. None of the state agency physicians discussed Ms. Jackson's opinion, and the administrative law judge provided no rationale for why those opinions were accurate. And on that basis, the supportability and consistency prongs of the regulation were not satisfied. And turning back to the issue of the cane, the Commissioner is also engaging in post hoc rationalization by supplying evidence that the judge did not consider or mention as evidence that Mr. Lincoln did not require a cane. The key here is that Mr. Lincoln used a cane in 2021 on 3 occasions and was observed to do so, and the administrative law judge didn't mention that. Because of that, the administrative law judge's decision was not supported by substantial evidence, and we ask this court to reverse. Thank you very much.
Thank you. Our thanks to both counsel. The case is taken under advisement, and that concludes the court's calendar for today. We are in recess.